Members, the House is resumed. Before the dinner break, we were on the second reading of the Housing Legislation Amendment Bill, and Peeni Henare was speaking and has 1 minute, 56 seconds remaining.
Mr. Speaker. Tēnā koe, Mr. Speaker. Thank you once again for this opportunity. Before the dinner break and the excellent chicken curry, Mr. Speaker, I was making reference to the faults around process. And I talked about the state housing sell-off and the engagement with iwi and Māori housing providers, and the answer to all of the questions I posed was none. No consultation, no sales to those people. So to part two, Mr. Speaker, and I want to pick up the point that Mr. Seymour made. Actually, with regard to the Treaty of Waitangi and the rights of first refusal, those who have already settled, Ngāti Whātua ki Ōrākei, Te Kawerau Maki, are just two of the bills that come to mind of recent times where their rights will be protected under their right of first refusal. Now, this House has already mentioned how that particular process was also fumbled by this government. We know that Ngāti Whātua were refused the right of first refusal. They took that to court, challenged that decision, and the court found in their favour. Now their rights are protected, and good on them. But I want to pick up the point Mr. Seymour made about those who don't belong to those iwi collectives, those property owners who were there many years ago when their land was acquired under the Public Works Act. Mr. Speaker, where are their rights? Where are their rights? And you know, as much as I've advocated for the rights under the Treaty of Waitangi, the treaty settlements process that takes place in this House, it's important too that, remember, in this conversation, the housing crisis affects everybody. So it's important that we look after their rights too. Just in conclusion, Mr. Speaker, I stand here on behalf of the Labour Party, and of course we look forward to the next stage of this bill. Kia ora, sir.
Cool.